And today we start our third thematic module. This is second half of our training course. And switching from more general transversal concepts of human rights and mechanisms to protect human rights, we proceed with more specific individual rights, their content, their protection. And we are so pleased that today the expert Ludmila Oprishko agreed to participate at this call as our lecturer because Ludmila has extensive experience of working in that area, protection of human rights, freedom of expression, freedom of speech. You could see in the materials that we sent that Ludmila for several decades has been working as the defense attorney and for more than 10 years in this particular area. She's also media lawyer of the Human Rights Platform NGO. Sorry for this barking. And so she is the expert of the Council of Europe and OSCE, and she practices on a regular basis representing interests of journalists, media in the field of the freedom of speech and freedom of expression. So I pass the floor to Ludmila. I will not take any more of your time. I'm sure that this lecture is going to be very interesting and our participants will be active today. Ludmila, the floor is yours. You can share the presentation. Let me mute myself, not for you not to hear my dog. Thank you, Maria. Thank you for introducing me. And I'm very grateful to you for this opportunity to participate in this International Human Rights School. Frankly speaking, I am really impressed with the number of participants in your school. And I have repeatedly been invited to deliver trainings on Zoom, using other online platforms, and I could hardly expect that we are going to have such an extensive audience. Thank you so much for inviting me, and thanks to participants for their interest for this topic. So I'll try to live up to those expectations, to support your interest, to make it really interesting and useful. Let's agree how we work. Now I will launch my presentation and I'm going to present the material. I'm going to present my vision, how I believe it would be reasonable to present it. But sure, you always have questions on the way. So for you not to forget them, let's write them in the chat box. The questions. If you are able to keep it in mind, your question, well, we can do that as well. So after I finish my presentation, we can all unmute ourselves and first we discuss questions in the chat box, and after that we can have an interactive discussion and you can ask those questions that are of interest for you or the other way around, we'll see. And now, as far as I understand, we are ready to start. If the organization household rules are clear, let me share my screen. So today we are going to speak about the freedom of expression. I understand, I guess, that since you've been discussing human rights, you always refer to the European Convention for Human Rights. At least the European Convention for Human Rights, as well as a lot of other international instruments, contain this right to the freedom of expression. And we are going to speak about International Covenant for Civil and Political Rights. And here we also refer to the Declaration of Human Rights. So there are quite a lot of international instruments that highlight this right, human right. So what kind of right is that? Let us try and understand it better. So freedom of expression Above all, this is the right that includes several components. Most often, we are used to speaking about freedom of expression as the freedom of speech. Actually, this is right. However, let us start with under the theory of human rights. So, what do we understand as the right to freedom of expression? Above all, this is about that the freedom of expression includes the right to have one's own opinion. So everyone has some opinion about some topics, ideas. We support some ideas, we share some ideas, and we absolutely oppose others. And the right to have one's opinion, this is a component right of the freedom of expression. Very often, when we speak about own opinion, we mention judgments. And further on, we will discuss what judgments are, why it is important to say judgments from facts. So when they ask to refute some judgments, it is the same as that they request that you abandon your opinion, you refute your opinion. And by the way, when there is the obligation, so sometimes attempts may be made to step away from one's opinion, and that it goes counter to the right to freedom of expression, which implies that all of us may have our personal own opinions. And also the right to freedom of expression includes the right to have, receive, and share information and ideas without interference from public authorities and regardless of state borders. That's a very interesting right, multi-component right. So let's discuss that in more detail. First of all, let us recall that international documents that stipulate human rights, they started adopting those documents after the Second World War, after those terrors that the humanity survived. And above all, these documents were adopted in order to protect humans from the state and interference of the state. That is why we see here this construct where everybody's right to look forward to receive and share information and ideas to everyone without interference from public authorities. This is the mechanism to protect individuals against influence of the state. So on the one hand, when this right was formulated, the practice was that it was recognized that the state cannot interfere into exchange of information. So if I want to tell you something, you have the right to hear that. If you want to tell me something, I have the right to hear that, and the state must not impede that. But at a certain moment, when public life started developing actively and becoming more complicated, the issue of access to public information arose. A lot of journalists, activists started speaking about that since I have the right to look for information, to receive information, obviously I can go to the state and ask the state to provide information publicly, the information that the state has. If the state has a registry, it means that it must ensure that I have access to those registries. So once in case law of the European court, they faced the issue whether the right to the freedom of expression includes the right to access to public information. Well, for a long period of time, the position of the European Court was that the right to access to public information was not recognized. It was believed that the right to freedom of expression only includes protection from the state and the right to exchange for individuals to exchange information. Citizens, those who want to convey this information and accept that information. And thus, the state was not supposed to have incur any additional obligations. But since a lot of countries started adopting laws that guarantee access to public information, publicly significant information, case law of European courts started changing, transforming, and now we can say definitely that the right to access to individual information also to public information so also falls into the scope of freedom of expression. To arrive at that conclusion, the European Court conducted the surveys and by started developing the respective case law. In contrast to a lot of national laws, it does not create those immediate obligations to the state to provide any information to citizens, but at the same time, in several decisions, the European Court admitted that in those cases where plaintiff acts as the watchdog, if they perform important functions and look for information that presents public interest, and this the state has monopoly to own this information, in that case, the state must provide such information upon request. A bit later, we will have a case study and we will discuss that in more detail. But now, it is important to focus on that the right to freedom of expression includes the right to access publicly important, significant information that is owned by public authorities. That's also the right that includes the opportunity for independent exchange of information and ideas without control by the state. No disregarding state borders, regardless state borders. So this right can be realized not only with friends, acquaintances, or within just one particular state. So this is limitless, borderless. Exchange of information is possible no matter in the territory of which state participants of this exchange or parties to this exchange live. What's also important, the third component of the right to freedom of expression, this is the right to independently choose the form of exercising the right to freedom of expression, including oral, written, through press or other artistic forms of expression, or in any other way at one's discretion. So what's important, that there are different forms for a realization of the right to freedom of expression. So they may choose any form to express themselves. And if we speak about freedom of expression, sure, most often we refer to mass media. These are traditional media, private media, newspapers, books, journals, magazines. And I see that we have here a lot of participants from Ukraine, so that includes Facebook as well. In Ukraine, we have two types of traditional media, printed media and TV and radio broadcasters, and also electronic media. By the way, in Ukraine, the status of internet media is still indefinite. We have a lot of internet websites that play the role of media. So they play the same role as mass media, but the status of this online media is still indefinite. We have a draft law that is aimed to address this issue. However, the discussions were so intense regarding the draft law that the draft law has been registered. However, it has not yet been submitted for hearing in the parliament. What is going to happen to this law further, we'll see, because there was a lot of criticism. So actually, mass media, that's not only about traditional media. Now, when information technologies develop so fast, the role of the internet grows significantly, and we can also say that the Committee of Ministers of the Council of Europe adopted recommendations on the new meaning definition of media. In those recommendations, they set criteria to determine whether certain resource is media. New media, including internet media. Now we speak about social media as a new form of media format. So when we speak about freedom of expression, most often we speak about freedom of speech. But actually, freedom of expression is not limited to freedom of speech only. I can show you now several slides so that you could see this. Yes, I could illustrate this statement. On the left here, you can see an unfinished mural that was thrown in 2017 in one of museums of Kiev, Mistецький Arsenal, and it is 1250th anniversary of baptizing of Kiev Rus. So they were preparing the exhibition, and so when they were preparing this exhibition, one of the artists, Vladimir Kuznetsov, he is quite well known, he had the opportunity to draw this mural on the wall. He discussed this idea with deputy manager of the museum. They coordinated that. However, they did not really approve any particular designs. So he started drawing, and this is what you see on the left.
Собственно говоря, вот в таком виде этот мурал был за день до открытия выставки.
So that was the way the mural was seen one day before the exhibition was opened. I'm not sure that you recognized the characters in this mural. Let me just remind you, it was back in 2012, before the Revolution of Dignity. And in summer, we had a tragedy when a woman was raped by the police officers, and the body of the woman, actually the woman, was dumped outside the village where she lived, and there was an attempt even to set her on fire. So she was subjected to torture. Fortunately, she stayed alive, and in this mural you see this woman. Then the entire village of Radievka took to the street to protest against police, against violence, to close down the police station, and they were protesting against unlawful actions of the police. So the artist that was called Kolishina, The Last Judgment, he decided to portray this woman who is standing next to this melting pot, simmering and boiling, and you see this characters of the celestial fathers that don't really serve the god but enjoy their power. So that was the images he had. So before the exhibition was opened, the entire mural was blackened out, and that led to the scandal in Ukraine, because it was prohibition to reveal horrifying scenes by painting it black. Though in the mural, the artist depicted the reality that existed at that time in Ukraine. And the message was to wake people up, to give a waking up call for the people. The director of the museum was really open to all the remarks, including critical remarks. I don't want to detailize it more, but I was just trying to show to you that freedom of expression is not only freedom of speech, that's freedom in creative artistic activity, that's freedom of expressing opinion through paintings, art, and other forms. All that is covered by freedom of expression. That's another piece of art. Again, that's Kiev. The author in this instant is Alexander Grechov, an artist that decided to depict Taras Shevchenko. I guess you know that's a Ukrainian poet, that's our spiritual leader, that's a reputable, respectable poet in Ukraine, for those who don't know the name. So Taras Shevchenko lived in the 19th century, or rather a few centuries ago, and the artist decided to imagine Taras Shevchenko in the modern world. What way would he look like if he lived today? And he had several paintings. There are just few of many that he did. I mean, the author did. And all these posters we put out in the city of Kiev, a metro station called Taras Shevchenko. And that caused indignation from the conventional thinkers, and expressed their indignation and anger. How come that's derogatory to the name of Shevchenko? How would you dare depicting him like that? And then at some point, one of the followers of the extremist group just cut these posters, and they were removed later. So this type of artistic expression is also covered by the meaning of the freedom of expression. So that was just the idea, the idea of the author of Taras Shevchenko in modern world. Okay, let's move on. Apart from art, apart from freedom of speech, the freedom of expression covers the right to wear different clothes, to look the way the person considers to be good. For instance, hijab was subject to criticism and wide discussion whether that's appropriate to wear it at schools. During the time of the pandemic, there was an issue raised of wearing masks. Would it be interpreted as part of freedom of expression? Since as soon as the person wears a mask, that deprives the person of the right to express himself. So that's the way the freedom of expression can be interpreted. Some other means and forms of expressing ourselves would be discussed later. Right now, let's talk about those who is entitled to have this right to freedom of expression. If you look at the international documents, including Article 10 of the European Convention of Human Rights, you can see that everybody is guaranteed the freedom of expression. So it starts with everyone. So everyone has the right. So what does everyone mean? Everyone means every physical person, including journalists, including public officials, actors, academia, scholars, authors, etc. Everyone, that's any person. Everyone means not only physical persons. Everyone means legal persons as well. For instance, news agencies, publishing houses. In Ukraine, we have a high-profile case when former lawyer, politician Viktor Medvedchuk submitted a claim against Kipiani that covered his past when he was a defense lawyer in a case of a well-known poet in Ukraine, Vasily Stus. So here we talk about freedom of expression that includes legal entities, that's publishing houses, that's media outlets, and anybody actually, including universities. In other words, that's any person and any legal entity that enjoys freedom of expression is covered by this right, by this guarantee that is established by the International Convention. And this right covers activists and bloggers as well, the social media users as well. The notion, or rather legal understanding of journalism is developing so fast that a lot of international acts stress that journalism under modern conditions doesn't cover traditional means only. So it could be also bloggers, freelancers, civil activists, representatives of NGOs and civil society organizations, writers, historians. In other words, anybody and all that act in the interests of the society and publish publicly significant information. Therefore, the right to freedom of expression is enjoyed by anybody who has it. Having enshrined this right in the international conventions, the governments that signed the conventions and ratified the convention, for instance, Ukraine ratified the European Convention on Human Rights in 1997 on September 11, and the governments that ratified international documents therefore undertook obligations to honor and enforce these documents. That includes the freedom of expression. And thus, they undertook negative and positive obligations by signing and ratifying conventions. Negative obligation is the obligation not to violate the rights that are guaranteed by the international document. In this case, these are the duties not to violate the right to freedom of expression. In other words, not to create any obstacles for the free exchange of information. What does that mean in practice? In practice, it means that representatives of the state should refrain from violating the right to freedom of expression. Why did I use the broken camera as the image? Very often, at least in Ukraine, we unfortunately deal with the instances when the representatives of the authorities themselves violate the right to freedom of expression. For instance, police officers smashed cameras and video cameras of journalists for them not to film and not to collect the information. We had instances when the protests were dispersed and journalists who were filming that were subjected to the tear gas and their work, their professional work, therefore was interrupted by the representative of the authorities, and thus they violated the right to freedom of expression as representatives of the state. Sometimes that's judges that interfere with the right to freedom of expression, for instance, when they impose high fines, and that causes deterrent effect and therefore violates the right to freedom of expression. So that's the violation of the negative obligations of the state when the state itself does not allow for the free collection, dissemination, and receiving information. However, well, there is another important case I wanted to mention here. Given the access to internet plays a more and more significant role in our life, and I wanted to attract your attention to a very important judgment that's called Ahmet Yildirim versus Turkey, that deals with access to internet. What was the issue there? Ahmet is a Turkish scholar who created his website on Google platform, where he put out the information he collected as part of his scientific research. It was different studies and articles that he put out on the website. Honestly speaking, there was nothing drawn about this website or platform. What was the issue before the court? The same platform, Google Sites, was used by the other user, where the latter disseminated information that was derogatory with respect to the founder of the Turkish government. Thus, the Turkish government instituted criminal case for derogatory statements with respect to Atatürk. Since it was the criminal case that was filed, the judges in their judgment imposed the ban for dissemination of the information through this website and removed this site, since the website contained negative information about Atatürk. When the government started enforcing the decision of the court, they realized that it is impossible to block the website. That's why they decided to block the entire platform, Google site. And following this blocking, Ahmet Yildirim couldn't get access to his website, to his articles, studies, research, etc. So he contested these actions of the authorities in Turkey. Unfortunately, he lost in the national courts of Turkey on the ground that there was a criminal case, and the decision was delivered in the criminal case, saying that the decision was an attempt to protect the citizens of the Turkey from unlawful derogatory content that was shamed to the name of Ataturk. So Ahmet Yildirim went to the European court, and the judgment in this case is really a landmarking because the court established violation of the right to a fair trial by virtue of which the access to the website established by the applicant was blocked for the applicant. The European Court, in the judgment,
Для понимания вывода
made very important statements,
интернет — это фундаментальное право.
whereby the court stated that access to internet is a fundamental right and the citizens are entitled to the access to internet. The court said that if
Незаконный контент, то блокировать нужно только
if it is unlawful content, then only unlawful content should be blocked.
ограничивают
And you cannot allow for unproportionate, broader blocking of the content when access to other content is also blocked. That's very important, especially given modern times, since internet is a very important means for all of us, especially now when it is internet that allows for our communication. Internet gives large opportunities for all of us, and we'll speak about this later. I will talk also about the other side of internet, but the flip side of it. But anyways, access to internet should be provided for, since that's very important for the development of a person, for enhancing education, knowledge, professional development. All that is possible thanks to internet. Positive obligations of the state. What does that include? There are many nuances here that are important to be aware of. Positive obligations of the state mean that the government or the state should act actively for all nationals who want to enforce their right to freedom of expression can do that. In other words, the state should facilitate enforcement of the right to freedom of expression. What would that mean in practice? In the duty of the state, that's under Article 10 of the European Convention, that mandates the government to protect journalists from unlawful actions committed by other parties. So, in other words, the positive obligations of the state to protect journalists was stated in the judgment Özgür Gündem versus Turkey. That's the newspaper that published a lot of materials on Kurds, their issues, their positions. You know that there are quite a lot of Kurds residing on the territory of Turkey.
So that is quite numerous people, but they still don't have their own state. At different phases of their history, they have encountered various armed conflicts, then that goes down and aggravates again. So the Kurd problem issue, that's quite a sensitive issue for Turkey. So actually, Özgür Gündem, that was the newspaper that expressed the position of Kurds. And since it published materials that caused, well, that were not always liked by many citizens of Turkey. So as a result, journalists of this publishing house were often attacked, battered, and even killed. There was homicide. And they also attacked their office building and they would put it on fire. So the editorial board and the journalists faced very challenging situation, and they often appealed to the government, asking the governmental bodies, asking them to protect them against these attacks. But the authorities were rather passive, and actually the journalists got no actual protection. As a result, several criminal proceedings were initiated. Those proceedings, those cases were uh, protracted. No, they arrived at no result. It took a lot of time, and the newspaper decided to go to the European Court for Human Rights, and there the European Court um, confirmed violation of the Article 10 of the Convention. This is violation of the right to freedom of speech. This is violation of positive duties of the state, meaning that the state failed to provide protection for the journalists, even though they mentioned that they were threatened, intimidated. However, the state was passive and did not provide them with protection, meaning that there was no thorough investigation of all of those incidents associated with that newspaper. That was one of the first cases where the European Court emphasized the positive duty, a positive obligation of the state to protect journalists and to investigate all cases of violation of their safety. The next positive obligation is efficient, effective investigation. So now we switch to that. This is effective investigation of all cases of attacks on media representatives. In this case, as Gundem, this is another case of ineffective investigation of attacks on journalists. But if we take a case from Ukraine, we could refer to Gangadze versus Ukraine case, even though it was not heard under Article 10. But anyway, that was about killing, murder of the Ukrainian uh, journalist Georgy Gangadze, who disappeared in the year 2000, went missing. More than 20 years have passed. But I should mention that the decision on the case Gangadze versus Ukraine, it was adopted back in 2005. So it was confirmed that that went counter to Articles 2 and 3 of the European Convention. However, this case is still being under consideration of the Committee of Ministers of the Council of Europe. And once every 6 or 12 months, they hear this case and it is still under control. So it is believed that Ukrainian authorities failed to ensure effective investigation because the uh, uh, customers, the orders of that murder have not yet been discovered, because for executors, and there are several sentences already. However, we don't know who ordered the crime. So it is still under control of the European Court. What are other positive obligations of the state? For example, the positive obligation to adopt respective legislation that guarantee the right to fair trial. That was the decision under one of the cases that I had in the European Court. This is editorial board of Pravedila and Stekel versus Ukraine. And this is the IHRSYA case. I uh, provided defense there both in Ukraine and in European Court. So that was a small newspaper. It was 2003, 2004. So it was published in Odessa. Mr. Stekel is editor-in-chief of the newspaper. And once this printed media, this newspaper, published with reference to the source, to website власти.нет, an anonymous letter of an ex-security service officer stating that the security service and Odessa office of the security service not so much deals with national security, ensuring national security, but rather they kind of hide smuggling and they protect various gangs. They mentioned several names, including the name of one of famous people in Odessa. Since the European Court doesn't mention this name, doesn't disclose the name, I will not do that either. But this is an important public figure in the city of Odessa. And they mentioned him as a participant of an organized crime group that was responsible for financing of that group, that he was their cashier or treasurer, and that he controlled also the ordered murders. And of course, this individual went to court and he, insisted that the newspaper refuse this information and compensates moral damage. In addition to this publication by the newspaper with a reference to the source, and they literally copy pasted the content from the prime source, there was also an editorial note in the newspaper stating that where the editor-in-chief said, I don't know whether this letter is true, is authentic, but since it is so striking, we cannot but publish it. So we are ready to give voice to all the parties to express their positions about the issues raised in this letter. So if you wish, you can come to us and we are ready to publish your opposing opinion. Or so, of course, nobody requested any publishing comments. So they went to court, and actually Ukrainian courts obliged the editor-in-chief to um, ask for excuse for this publication, and there was 15,000 hryvnias of moral damage. It is about 3,000. It was about $3,000. That was quite a significant amount for that minor newspaper, which was not well funded, which did not have a lot of income. So we went to the European Court and we insisted, we stated that actually the newspaper published the information that it found from another open public source. And actually it was punished because it reprinted the information received from other sources. However, the newspaper did not insist on that that was true, and they were kind of offering that for discussion. They were ready to publish opposing, alternative opinions for those who were involved. So we stated that the uh, newspaper was behaving properly according to the law, and actually there are the laws that protect journalists in that case against accusations of defamation. Well, if this were printed media who just reprint this information, they would not be liable. If it were not internet media, but TV or radio broadcasting, again, there are laws that relieve them of this liability in case they just reprint word by word information from other media. But since online media in Ukraine are not regulated, and now we don't have legislative regulation or legislative framework for that, actually the online newspaper had to pay the price because the legislator has failed to give proper definitions to online media. So there, the decision of the European Court was that positive obligation of the state was the duty to adopt legislation guaranteeing, securing the right to freedom of speech. And since we've mentioned this case, let me add something else. This is not linked to positive obligations, but there is another case that seems to be very important if we speak about dissemination of information via the internet. Because here, in this case, the European Court emphasized that there are some specific features for online technologies. So according to its decision, the internet is a technology that is significantly different from private media and from electronic media. Internet media have their specific features. That's about that the information is disseminated fast, travels fast, it is preserved, stored for a long period of time, and it covers a huge number of people. There are a lot of positive aspects there, but a lot of negative ones too. So if unreliable information is disseminated, the one that undermines dignity of other people, this information may be much more damaging than information published in in private media or on TV or radio. If a newspaper publishes a defamating article, well, you read it once and you forget about it. Same refers to TV, even though TV has greater impact, but in the internet, on the internet, you have everything preserved forever. You have access to information 24/7, and thus there is greater impact on other human rights. In that connection, the European Court in this case stipulated that this technology cannot be regulated in the same way as printed media or television and radio. This is the specific feature of internet media, and it means that it is necessary to look for another approach in line with online, the specific features of online technologies. And actually, the conclusion was that states must adopt laws that guarantee, among other things, the right to freedom of speech on the internet, especially for fair journalism practices. What's also important, another positive obligation of the state is eliminating barriers for the media to perform its functions arising due to state monopoly on information. And you can see in the brackets the name reference to the case. It is a bit different in the English translation, so I may browse for that. The Hungarian name is very difficult to reproduce, you know. The Hungarian language is rather specific. But you see the number of that application and you can browse for that. So this is about access to public information. There it was about that an NGO that deals with the drug trafficking problem issue went to the Constitutional Court of Hungary and requested that the court provided them with a copy of the submission or motion that was submitted by one of MPs to the Constitutional Court. It is about amendments to the Constitutional Court, to the Criminal Code. And it was important for the NGO to see arguments of the MP why he initiated amending the legislation, drug trafficking related laws. So they wanted to read, to have a look at that application or motion, but they request was rejected because that was interpreted as interference into the MP's private life, because that motion could disclose his individuality, individual aspects. They exhausted all the national mechanisms, and the NGO decided to go to the European Court for Human Rights. And in this case, the European Court said that the positive obligation of the state includes elimination of barriers on the path to collecting information, which is publicly important. If that information is monopoly of the state, if the state has monopoly on that information, in that case, it was the Constitutional Court. So this was a short, brief review of negative and positive obligations. And actually, if we go into more detail, we now need to switch to the role of journalists and mass media in a democratic society. Most court decisions made by the European Court for Human Rights address these issues. In any decision, you will see a whole list of principles that the European Court was guided by when hearing specific cases under freedom of expression. Most often they focus on the following. Above all, the European Court always states that the freedom of expression is the ground for democracy and individual self-realization. Well, the freedom of expression is a comprehensive right which forms the foundation for a number of other human rights. And I know that your next lecture will be on peaceful assembly. So peaceful assembly and the freedom of expression, they go hand in hand. They actually mutually enhance each other. And if we speak about the right to fair trial, that's also hardly possible without freedom of expression, without journalists and media access to the hearings, court hearings, without publicity. And now in many countries there are elections. In Ukraine we have local elections. So the right to vote for the parliament or other authorities, that's not possible to ensure that without the publicity. And that is the basis of democracy. However, at the same time, right to freedom of expression is complemented by a range of rights. If we have time, we can cover that.
Nevertheless, in this regard, I would like to underscore that the right to freedom of speech and freedom of expression, that's the basis of democracy, without which the democracy is impossible. And that's special value of this right, since any democratic state is to enforce the right to freedom of expression, freedom of speech. Here, it's very important to note the role of mass media in a democratic society. The European Court keeps stressing that journalists and mass media have a role of a watchdog of democracy. So they are protecting the interests of democracy. That means that journalists are to respond to any issues that the society is facing. And they not just have this right, but they are obliged to cover all these events, and the citizens of the country are entitled to receive this information. That's what the European Court reiterates all the time. I haven't seen a single judgment of the European Court where European Court wouldn't underscore these important principles. Another important thing is that democratic society allows not only for the expression of the opinions that are positive, nice, and are easy for the perception. On the contrary, democracy and the freedom of expression do mean that everybody has the right to express the ideas that bother them, that are outraging, that are shocking to somebody else. That's an indispensable part of freedom of speech. Additionally, the European Court stresses that, in fact, the right to freedom of speech is protected not only when it comes to content, but also it covers the form. There is a judgment where it deals not really with the censorship because it doesn't exist, but uh, the words and expressions that are considered as coarse language or foul language, in some instances, are protected too by the right of freedom of speech or expression. For instance, the author describes some scene, and it's very important for the author to create a special environment. So the author is allowed to resort to the foul language to truthfully depict the characters and environment. So it's not only the content, but also the form that are protected by the right to freedom of expression. Two other judgments dealing with the freedom of expression. The first is Shvedka versus Ukraine. That's the judgment delivered in 2014. Shvedka, if you translate, that's the last name, though they are not translated, but if you translate that into English, that would be the person who is Russian all the time. And to some extent, the last name is characteristic of the person. What is the case about? In the middle, you see the picture that's downtown. That's Shevchenko University, right building of it. Across the road from the university, there is the park named after Shevchenko with a monument in the center of it. On March 9, that's the birthday of Shevchenko, a famous Ukrainian author. Then the president of Ukraine was Yanukovych, and he laid the rest to the monument of Shevchenko. We have several stories that were laid down by President Yanukovych, but in this instance, the rest contained the ribbon to a famous Ukrainian author from the president Yanukovych. When the high officials left the park and the monument, one elderly lady came to the monument and she ripped off part of the ribbon. That was the part where it was written from the president Yanukovych. So you can imagine the situation. So immediately she was approached by the police unit and they issued a protocol on violation of public order. I think in many countries there is an article on hooliganism, and we have hooliganism that is covered by criminal liability. This one is covered by administrative, since it was minor. The lady was 63 at that stage, so the protocol was issued. The case was instituted. She didn't plead guilty, and she said that I don't believe that Yanukovych is the president of the country. I am a supporter of a Batkivshina party. The leader of the party is Yulia Tymoshenko, and at the presidential elections, there was really a small difference in votes between Yulia Tymoshenko and Viktor Yanukovych. Yulia Tymoshenko lost. It was really a small percentage of votes that she lacked to win the elections. And Madam Shvedka said, well, I don't believe Yanukovych is the president of the country. It's just my opinion. The court ruled to keep her in custody for 10 days and stated in the decision, since the person didn't plead guilty and did not did not repent, the court ruled for her to serve 10 days of custody. Well, the appeal was heard 1 or 2 months after Shvedka served the sentence. The appeal court revised the decision of the court of the first instance, but it upheld it. It didn't change the decision of the trial court. So what's the idea eventually? Ms. Shvedka went to the European Court, and the European Court heard the case not only under Article 6, but under Article 10 as well. Article 10, that's freedom of expression. The fact that she tore part of the ribbon was her expression of political opinion. And well, that was the way she expressed her political opinion. And for that, she was deprived of freedom. And that was the first wrong act of the state when they took this act as a violation. If the person violated law, but by doing so, the person expressed opinion, then criminal liability cannot be imposed. There are only several instances when it can be justified, when it is terrorism or support or funding. Well, there's a limited set of grounds when the European Court can agree that criminal prosecution can be resorted to in the instance when the person expressed opinion. So custody cannot be imposed for expressing opinion. That's one important conclusion. Second, the statement of Ukrainian court, when it said that the person did not plead guilty, did not repent, and therefore should serve the term in detention facility, was seen as the requirement to the person to give up on their opinion and change their opinion. And the European Court found it as a violation. So the freedom of expression is not only just freedom, but the actions that serve as the form of expression of opinion. Nikolai versus Russia, that's the recent case. We a year ago, the European Court delivered a judgment in this case that dealt with dissemination of flyers. Mr. Nikolaev on September 1 came to this school, and the conflict between him and the principal of the school started a long time ago. They were members of the election commission. The principal of the school was the chair of the election commission, and he was a member of this commission. And at one of the meetings of the commission, the head of the commission expelled Nikolaev from the sitting and terminated his right to participate in the meetings of the commission, and he was expelled from the commission. And on September 1, Mr. Nikolaev came up to the school where this lady was the principal, and at the meeting when people got together to celebrate the beginning of the tuition of the academic year. He started handing out the flyers, saying that, okay, why would you go to the school? Because the principal of the school, well, it's the rights. How can she teach your kids? The principal of the school realized that that's this guy who was handing out the flyers and leaflets, and she asked the security to do something about this. And when the security started first figuring out what kind of flyers he was handing out, then they wanted to stop him from doing so. Anyways, they called the police, and the police issued protocol. And Mr. Nikolaev faced administrative liability, but he appealed this, and I can't remember at the moment whether he was sanctioned. But anyways, at some point, the government realized, okay, these actions cannot be resorted to with respect to Nikolaev. Anyways, he lost the case in Russia, and he went to the European court, and the court found a violation of Article 10 because he was banned from handing out the leaflets or the flyers. And this ban was done in the manner that's not provided for by law. So they issued protocol for the things that were not drawn. He didn't violate anything. So the police didn't pursue legitimate goal. So that was a rare case when the court established lack of legitimate goal behind the actions of the law enforcement agencies. So that was done in relation to Article 5 as well. So we move over to the next very important scene. Well, more than an hour, we covered the elements that are covered by the freedom of speech, freedom of expression, and how it is protected. Now, we need to say that with all the significance of this right, with this right being so fundamental, it's not an absolute type of a right. We said that it strengthens a lot of other different rights, but at the same time, it is in conflict with many other rights. So that means, well, that this right can be limited. That's not absolute. So when and how this right can be limited? There is a test that allows to do that. And the first element of the test to limit the right is the following. Any limitations to the right to freedom of expression should be prescribed by law. They should have legitimate aim. And 3, they should be necessary in a democratic society. I'll comment each of these elements. The first, prescribed by law. What does that mean? European Court has never provided definition of what prescribed by law means. whether it includes laws only as legal acts, or that's legislation in a broad meaning of the word, or that includes precedents as well. Given the European Court case law, if you look at many judgments it delivered, prescribed by law can be understood as following. It includes not only the law. European Court says that the notion prescribed by law should be interpreted reasonably, and they shouldn't establish how this should be done by the national level, but it should be done under the supervision of the European Court. So the European Court exercises supervision so that the national courts do not have really broad discretion, but rather comply with the European case law. So when we see prescribed by law in Ukraine, Ukrainian lawyers normally say that Ukrainian legislation distinguishes between law and lawmaking. Lawmaking is a broader term that includes laws and bylaws. That's why when we look at Ukrainian laws and see that limitations should be prescribed by law, that means that that's prescribed by the acts endorsed by the Parliament of Ukraine, and that should be the act that is made public. In other countries, it could be different. We have countries with case law, with precedents, for instance, UK, and the precedents that exist in UK are considered to be the source of law, and they have the status of law. So the jurisprudence is taken into consideration. Well, it's very important to understand what prescribed by law means. And it means that it's not sufficient to have the ground or the precedent. It is necessary that the law is accessible. So the law should be made public, should be published and available, accessible for citizens. And another important thing is the quality of law. That's what the European Court stresses. And European Court reiterates that the law should be clearly stated, and thus this would allow to foresee the effects of the actions. And there is a reservation that it's impossible to provide detailed wording of the provision, because the law is not the instruction for every case. You can't cover virtually everything there. But at the same time, the law should be clearly worded to the extent it is possible, so that at least with the help of the lawyers, you can foresee the effects and impact of actions and inactions. And if you speak about the quality of law, I mentioned Pravedel and Stekel versus Ukraine. So in that case, European Court found a violation of Article 10, just because inter alia it found that Ukrainian legislation at that time, on the one hand, exempted diligent journalists from responsibility, but these rules did not cover the journalists that took information from internet.
And since there were so many contradictory provisions, it was very hard to forecast the consequences of the actions. And the European Court in that case confirmed violation of Article 10, right to free, to fair uh, trial because of low quality of laws, because there were contradictions in the legislative framework. The next criterion which makes it possible to limit freedom of expression, this is legitimate goal. Now, on the slide, you can see the list of legitimate aims where it is possible to limit the right to freedom of expression in the interest of national security, territorial integrity, public order, to prevent disorder or crime, protection of health and morals, protection of the reputation or right of others, and defamation complaints, they go there. So to protect against defamation, it is possible to limit freedom of expression. For prevention of disclosure of information received in confidence, that's also possible. And for maintaining the authority and impartiality of the judiciary. And you may say, what is that really freedom of speech if you can limit that? But actually, if there is legislative framework and if there is legitimate aim, it is not sufficient in order to uh, ground to substantiate limitation of the right to freedom of speech. You need another criterion, necessity in a democracy, in a democratic society. On the so at the first look, it seems to be very vague. Necessity in democratic society. However, actually, the European Court, in a number of decisions, helps us understand what needs to be taken into account in order to understand if that limitation is needed in a democratic society or not. So what does the court take into account? First, if there was acute social need to limit the right to freedom of speech. So it's not just about that it would be convenient or uh, advisable to limit freedom of speech to protect somebody's reputation or authority of justice of the judiciary. Now that's about acute need. In that case, they take into account the context under which circumstances a certain event takes place. That's so important because if something happens in the context of elections, the margin of criticism is so wide. Or, for example, if it is about such phenomena that are threatening for humanity and for humans, like disasters, catastrophes, something that is kind of tangible and significant danger. And there, uh, you have very limited opportunity to reserve to limit freedom of speech. So you always need to take the context into account. Then it is about presence of public interest. Presence of public interest, if it is there or not. And of course, they also assess the form, facts, or value judgments. Can you hear me? I see that I have some internet issues. Now we can hear you. Okay, then let's continue. Moreover, even if in the context where something happens, some event happens in certain context, there is public interest, there is the status of the person, of the entity, of the person. It is also important to ensure proportionality of that interference. So if we limit freedom of expression in order to protect somebody's reputation, we should not overdo that. We need to limit it exactly as much as makes it possible to protect reputation, but without undermining freedom of speech. In this case, where we speak about criminal sentences, especially imprisonment. In those cases, as a rule, the proportionality principle is violated. I mean, it's very important in that context to take into account the punishment of mass media or journalists for abuse of freedom of speech. And also justification. These are the motives that need to be provided by those authorities that limit freedom of expression. They need to be appropriate and sufficient, adequate. All of that is taken into account. And all everything is taken into account cumulatively. This is both the need and legitimate goal and all of the factors that influence the need for this restriction, limitation in democratic society, or that refute this need. And an example for you, Ukrainian press, Ukrainian media group versus Ukraine. This is the first case that the European Court for Human Rights heard about versus Ukraine. This is the first media-related case under Article 10, which Ukraine lost actually, and the Ukrainian media group won. And there, it raises all of those issues and aspects that help to make it clear what we mean by need, necessity in democratic society. This is about the facts and judgments. This is about limits to restriction of freedom of speech during elections, form of expression. Let me tell you a little bit about this case. Maybe not all of you are familiar with that, even though it is like classic now. So that was about events of 1999. Those were events on the eve of the presidential elections. Back then, the second president of Ukraine, Kuchma, was going to be re-elected for the second term. And then there were also candidates from the Communist Party of Ukraine, Mr. Simonenko. And there was the Progressive Socialist Party led by Natalia Vitrenko. And so during the elections, election campaigns, you always have some plans or strategies that make it possible for the candidates to lead in that kind of competition. So the Ukrainian media group is publishing house for Den newspaper. So in that Den newspaper, a journalist Tatiana Koropova published an article where, well, which was about this kind of political layout. What strategies the parties pick up so that Kuchma did win the elections eventually and became the president of Ukraine for the second term. And actually, in this epigraph, she to her article, she states, and it is all about her, about ours and yours, Natasha, about the place that the progressive socialist Natalia Vitrenko may or may not take, depending on which of Bankova scenarios will ultimately win in the tender for office number one. Well, Bankova, it is the Bankova Street where there is the presidential administration. And of course, with a discount on taking into account the degree of error in predicting the object manageability. The first option was outlined back in spring, and it was based on the presumption that Pyotr Simonenko, according to Bankova, is not handsome and bright enough to play the role of a horror story in the electoral scenario a-la Rus reformer against the red threat. Natalia Vitrenko with her uranium mines and Vladimir Marchenko is much more impressive. So actually, after publication of this article, after it was printed, oh, this is just the epigraph, there was a lot of stuff in the newspaper. There was a cool fable. Unfortunately, we have very limited time, so I will not quote it. But I recommend you to read that decision. That's interesting. So in the context of these issues that we're discussing today, you see that was about that Natalia Vitrenko, leader of the Progressive Socialist Party, was referred to as a horror story, as a loudspeaker of Bankova or of the presidential administration. And so it is all about her, about our and your Natasha. So Natalia Vitrenko didn't like that. She complained, she requested that they refute this information, the article in full. She said that this is about fantasies that are not grounded on facts. And so it was just about that, that was defamation. They just wanted to offend her. And back then, Ukrainian courts agreed with that. And their judgment was to actually pay the fine 1,000 to 2,000, and they requested refutation of the article. There were two complaints by Simonenko, the leader of the Communist Party back then. Now the Communist Party is prohibited in Ukraine, and actually he also won his case based on the same presumption. So either that 1,000 was paid to him or to Natalia Vitrenko, 1 or 2,000 hryvnias. So there, the Ukrainian media group went to European Court for Human Rights, stating that Ukrainian courts did not delineate facts from judgments. The plaintiff also complained that all of these statements were made in the context of elections, and thus the criticism allowed was very extensive, because that was about politics, about known politicians, and the limits for criticism of politicians are quite wide, the margin is wide. All of these issues were of public interest because voters had to make a choice, and that needs to be an informed choice, informed decision. So it was important to explain it to the voters, what the actually the situation was. So the position of День newspaper's publisher was very strong. And when the government could received communication on that case, they realized that they would lose the case, and they suggested amicable agreement to the newspaper with complying with all the procedures, and the newspaper was even ready to accept that amicable agreement. However, the European Court did not approve that. The court assumed that that was about very important for case law, for legislation of Ukraine, about very important aspects. So unless this case is heard now, actually all the case law will further develop in an inadequate way. So the European Court did not approve of that amicable agreement, but they made a decision on violation of Article 10. And there they clearly stated that these expressions like horror story or loudspeaker of the presidential administration and other statements that were made about Vitrenko, that those were all judgments and you cannot refute those judgments because actually you make someone change his or her opinion. And at the very beginning, we did mention that everybody has the right to his or her opinion, and nobody has the right to make them change their opinion. Moreover, in that particular case, they emphasized the limits of criticism and with public interest. That in the context of elections, there is really high level of public interest to those aspects that were covered in the article. And actually, that was about known politicians engaged in participating in elections. They were candidates for presidency, so the margin for their criticism were quite wide. And actually, there, the European Court not only confirmed violation of Article 10, this is the right to freedom of expression, they also made and the government of Ukraine pay 33,000 euros to cover the moral damage, to compensate it. Well, of course, that was much, much more than the cost incurred by the newspaper. And that was a precedent that was supposed to make Ukrainian authorities revise the legislative framework and the judicial practice. And that's what happened. That was a starting point, actually, after which in our legislation we have the article in the law on information on that nobody can be brought to justice for expression of evaluative judgments. And there was even the definition of that term. Well, you may criticize it, but that had this important historical role. And the judicial case law actually changed dramatically after that decision of the European Court. Many courts are now more cautious addressing these issues and they try to delineate facts and judgments. Sometimes they succeed, sometimes they don't. However, the process is ongoing. And let me mention another case. This is Novaya Gazeta and Borodiansky versus Russia. On the right, you can see the number of that case. You can browse for that. Well, Novaya Gazeta and Borodiansky versus Russia, and there is another case, Novaya Gazeta and other journalists versus Russia, so there are several cases. Novaya Gazeta is an opposition newspaper and with a lot of um, materials, a lot of criticism, and so there are several cases in the European Court, but I decided to focus on this one because it is important to understand how to use this concept of delineation of value judgments and facts. The European Court actually in all of its decisions under Article 10 emphasizes that facts are something that can be confirmed. So they do not even offer definition for facts. They just explain that facts, it is something that can be confirmed or proved.
Contrary to facts, value judgment cannot be proved. How would you understand where it is a fact, where it is the judgment? You have to value the feature, the publication, the entire information, the information in its entirety, consider the context. Additionally, you need to consider if there is any ground for value judgment. So the focus in other words, is in the fact that if it is a value judgment, then anyways, the value judgment should be based on some factual basis. When we work with journalists to understand this principle, we say the following: a journalist can make a mountain out of molehill. But the most important thing is that the molehill should be real. So, in other words, the right to freedom of expression guarantees the right to exaggerate, to evaluative judgment, to exaggeration, but it should be based on the fact. That's a must. If the factual basis is missing, then the European Court can state that the right to freedom of expression was abused and not to find violation of Article 10. So this case, heard by the European Court, it seems to me it was the first case of Novaya Gazeta before the court. In this case, Novaya Gazeta and Borodiansky lost the case. Before the court, the newspaper published an article on different corruption offenses, and the journalist commented that the corruption links could not have existed unless one of the governors would protect them. So this statement that, well, allegedly the corruption links were covered by the governor indicated that the governor was implicated in corruption schemes that were committed. The governor filed the claim to protect his dignity and honor, and Russian courts established that this type of statement was ungrounded and ruled to refute it and even awarded some compensation for moral damage. The journalists believed that the judgment is unlawful because in this instance they made a value judgment and they said, well, we didn't mean to be offensive with respect to the governor or to humiliate him. It was our overall assessment of the situation. But when the European Court requested them to provide proof of at least some involvement of the governor in corruption schemes or some kind of implication in corruption offenses, the journalists could not do that. They didn't have any facts to prove that. That's why the European Court did not establish violation of the right to freedom of expression. But there is a lot more of other cases that were lodged after this case, where the situation was different. The journalists were prosecuted for their value judgments, but in these other cases, European Court found violation of Article 10. But this example, this case serves as an example of what should be the basis for your value judgment. If that's the value judgment that you express, you need to be able to prove that it is based on the base. There are different boundaries for acceptable criticism for different types of persons. That's the widest for the public officials. Public officials, these are the persons that hold official positions or make use of public resources, and all those who play some role in public life, politicians, economists, that's area, social life, or sports, or any other area of our life. If you talk about the broadest boundaries of acceptable criticism, so that's the government that falls into that. And there is a list of judgments of the European Court where the government was subject to criticism, especially when the issues of freedom of speech was at stake in the situation of armed conflict, in the situations of political turmoil. And the European Court always underscored that the government takes the domineering position in the society. That's why the acceptable criticism enjoys wide boundaries. That also covers any influential person, businessman, politician, etc. If it is civil servants, including judges, the boundaries of acceptable criticism are a little bit narrower. European Court explains it by saying that you cannot undermine the trust to state institutions, to governmental institutions. So, in other words, it is inadmissible to resort to ungrounded criticism of public officials or labeling them, since it undermines the credibility of the authorities these civil servants represent. At the same time, the constructive criticism or the criticism that clearly reveals the abuses or violations committed by a civil servant is an element of democratic society. It is admissible, but you cannot make statements like all judges are corrupt or all civil servants are corrupt officials. If you resort to labeling like this, then you'll undermine the authority of public institutions, and it is unacceptable. And ordinary persons, that's the group of people that enjoy the narrowest boundaries of acceptable criticism, that's private life, and that is really wide. I know that the time is of an issue. Public interest, just a couple of words on that. As soon as we have some rallies, naturally they cause public interest, and the boundaries to limit the freedom of expression here are very narrow. And on the left-hand side, you see Ukraine. Ukraine received Thomas. A lot of churches started switching the church. They were reporting to Russian or Ukrainian, and in many villages that led to conflicts because the community was split into two parts. And you see that's the TV channel, the feature called Fight for the Church. It is of public interest too, because it is related from the change of one church to another, and that's a fight there too, and it is of public interest. Or this one, that's a different story. On your left hand side, you see kids fighting, the girls are fighting. That's bullying, violence, and cruelty that you see among teenagers more often when teenagers pick up a victim and subject the victim to humiliation and bullying. Is there any public interest? Well, in the issue itself, that's right. But what about these kids, these ordinary kids and filming kids when they violate public order that's clearly governed by law, not allowing to make it public? In this instance, you see that the faces of kids are blurred, and it means that journalists did not cross the red line. Their task was to reveal the interest that could reveal the issue that could be of interest to large public, bullying at schools, but they didn't disclose the personalities of kids. So public interest is covered, but within reasonable measures. And on your right hand side, you see extravagant looking man. Well, we don't know him. Well, I personally don't know him, that's for sure. So it's not a politician, it's not a well known politician, it's just an ordinary person. So this type of filming him, taking picture of him, would it be a violation of his private life? Is it allowed to take pictures of him and disseminate this photo? Look at the way he's dressed. He has a bright wig on, he has female stockings on. So, but the way he looks, he you can tell that for sure that he did his best to attract attention to him. So he stands out against other people. That's very different from the commonly accepted norms, and naturally he attracts attention, and he's not trying sort of to close his face. So since that's the way he sort of expressed himself and meant to attract attention at this particular time, in this particular place, there is public interest to this particular person because people are entitled to know how extravagantly other people express themselves. So that's basically it. That's the end of my presentation. And we have some time left for Q&A. I see there are some questions. There are quite a few. We do have time for Q&A. I think we can have 15 minutes for 15 or 20 minutes for questions and answers. Okay, let's take a look at them in the order they were raised. There was a question of the banners with the Taras Shevchenko quantum leap. The person who cut these posters, is it freedom of expression? Well, given the context, it's very important to remind that freedom of expression is not absolute. And you can take this act as freedom of expression too, in a way, but I wouldn't call it freedom of expression. I would call it abuse of freedom of expression, because this way he destroyed the pieces of art created by the other person, and any destruction, any aggression is not protected by the right to freedom of expression. And there are many cases where European court, when considering applications under Article 10, dismissed them, finding them inadmissible, and spoke about Article 17 instead, right? That was abused. In many instances, it was to do with the instigating hate, hate speech, or disseminating and supporting terrorism, discriminatory type of statements. they are not protected by the right to freedom of expression. That's deemed to be abuse of the right, and the fact that these posters were destroyed is considered abuse of the right to freedom of expression. It's just an uncivilized act. Well, vandalism, somebody said. Yeah, true. Glasses on the picture. Let me avoid answering this question. Let me stick to some other questions. Somebody says that in their country they don't face this issue. The journalists are just imprisoned. Unfortunately, as I said, depriving the depriving of the liberty when the person expresses his opinion is considered to be unproportionate, even if journalists violated some norms and standards. That's excessive punishment for expressing opinion. If the person made graffiti and the utility company blackened it, is it a violation of the right to freedom of expression? Well, we need to look at this in the context, whether there's a violation of welfare conditions. If you look at this in more detail, so whatever premises we talk about that's protected under copyright law, and the person who made graffiti is covered by the copyright law. I think the issue is more or less clear, and if you want to learn more details about that, let's leave it for later, because there are some other questions and I want to answer those questions as well.
Возможно. Если да, то в каком объеме?
Potentially, yes. Then to what extent the right to expression is limited when it is social media, especially when it is disinformation is disseminated on pandemic caused by COVID. I mean, Armenian case. I didn't quite get what is it all about. I can quote Ukraine as an example. In Ukraine, social media saw a lot of fakes related to COVID-19 pandemic, and the fakes vary. It could be really kind of minor. For instance, there are swans in Venice just because of pandemic, though de facto there are no swans in Venice, and the picture that was put there to show the swans was really fake. But they were really serious type of fakes that were scary. And why am I saying this? Ukraine Administrative Code has an article on dissemination of false information and rumors and gossip. While the quality of the provision leaves much to be desired, but when quarantine caused by COVID-19 was introduced, we saw the increase in administrative cases under this article. But the materials of the case were collected in a negligent manner, and thus people charged under this article were acquitted. So and they stopped charging people under this article. So we see the increase in the number of cases, but nobody is charged for violations under this article. Okay, so that's the story that we have. If you meant something different, could you please specify later when I finish answering other questions?
Андрей Щукин пишет. Скажите,
Drish.
пожалуйста, меня задержали на митинге как
I
участника
was detained
протеста.
at a
Я
meeting, at a
информирована, что
protest.
журналистика
I had the
должна
status of a
принадлежать
journalist. I had
государственной
the
организации,
yellow vest with the observer
телевизионная
inscription.
организация.
I had the
Но, к сожалению,
editorial
когда меня
commission
задержали,
and
у
the
меня
camera,
не
but
было возможности
unfortunately, when I was
представить
detained, I had no
как раньше
opportunity to
происходило
introduce
в
myself
форме,
because that was
о своем специальном
in
статусе
the violent
рассказал
form.
суду,
I mentioned my
когда
special
дело рассматривалось,
status
когда
in
рассматривалось
court
административное
when
правонарушение.
the case was
Дело
heard.
было прекращено за отсутствием
So the case
доказательств.
was suspended because of
Впоследствии я подала исковое
the
заявление
merits. Then I
об
submitted the
жестокости
application
журналистов.
and complained about
Национальном
actions of the
уровне
police, but
и
at the
проиграла.
national level, I
Скажите,
lost
поручение
all
попадает под статью 215
my
Конвенции.
cases. So can it be
Вам
covered
было
by Article 10 of the
разрешено
Convention?
наблюдать.
Well, you had the observer vest.
Очень спорная ситуация. Знаете,
Well,
я
this
просто не
is
буду подробно
an
рассказывать,
ambiguous
но
situation. I will
действительно
not
есть
go
много
into detail
нюансов,
because unfortunately we
которые
don't
нужно
have
представить.
that much time.
Действительно,
But let
закон
me just
Мордовии
mention
называется
there was
«Принтикайнен
case
против Финляндии».
Printikaimen versus
Это был
Finland.
журналист, который
That was
работал
also about a
вместе,
journalist who
который работал вместе,
worked
где проходила акция
in a place
протеста,
where there
и
was a
порядки были
protest,
нарушены
there were
журналистами.
riots, and they were detained
Он
as
не
well
был
as other
идентифицирован как
participants.
журналист.
He was not
Это тоже
identified as a
проигрывает суд.
journalist. That was
И вот суд
discovered by
объяснил,
court,
что
and
поскольку
the
он был не
European court
наказан,
said that since
поскольку
he was
так
not
быстро разобрался, что он занимается
punished, as
журналистской
soon as the
деятельностью,
court heard
то поэтому в нарушении
the
судебного
statement that he was
постановления.
journalist, he was released, that was
Вот
not
посмотрите,
violation of
какая
Article
проблема
10.
с этим.
So you need to
Видите,
check
так
if
происходит в
that
Политбюро.
case is applies is relevant for you. Pietikainen versus Finland.
Так, Светлана Филиппова. Таких грязных выборов в органы местного
Those were
самоуправления,
the
которые
dirtiest
проводили
elections for local
в
governance
годы независимости. Согласна.
as we had on the
В
25th
Беларуси
of
бывший президент просидел
October.
несколько лет.
I
Журналистам
agree.
и женщине
In Belarus, you can
дальше
be
сейчас.
imprisoned for
И
for
если
criticism of the
общественному
president.
деятелю
Is that
допустить
limitation of freedom of
сравнение
speech?
с
Yes, of
импичментом,
course. If this is value
то
judgment about a public
однозначно
figure,
это
absolutely, that
формально
falls
говорить о нарушении
under
прав
that category.
информационной
That may be seen as violation of the right to
свободы.
freedom of
Так вот,
speech.
если чужое мнение наносит
Then, if
вред
somebody's opinion is
дискриминационный, государственный
discriminatory
характер,
and
возьмите,
degrading,
например, одну из групп меньшинств.
if it is addressed
Также
against one of
существуют
minorities,
инструменты, которые
there
регулируют
are
потребность
instruments
негативного
that
отношения к
regulate this
группе,
negative attitude
допустим,
in a
права
group,
женщин.
like women's rights.
Такое высказывание все равно прикрывают
But
свободой
that
мнений.
statement, they
Данная
try
группа
to justify it
соответствующих
as a
протестов
freedom of expression, even
не
though it is
будет
discriminatory. Well, any
не
hate
защищается
speech
правом на свободу выражения.
uh, n-
Любой
uh,
группы.
is not protected by the right to freedom of
Дресс-код
expression.
на
So if
работе,
it is about hate
ограничение
speech,
общего
dress code
диалога.
at work,
Если
dress
на
code
работе
at work
среди
in the
сотрудников
office is that
неприятные
limitation.
ощущения,
Well, if it
то
is
это
not excessive,
не нарушением прав на
then that
свободу
will not be seen
слова
as
выражения.
violation of your freedom of expression.
Что хотела привести
What
еще
else?
пример,
I wanted to
к
mention an
сожалению,
example.
потеряла.
Unfortunately, I lost it now.
Идем дальше.
Okay, let's move
Может
on.
ли журналист подвергаться
Can
уголовной
a
ответственности
journalist
за
be
распространение
subject to
неправдивой
criminal
информации? В
liability for
Украине нет.
defamation? Well, not in
Вот
Ukraine,
в какой стране есть
but
разные страны по разным
there are
регулированию
different
этого
countries
вопроса.
and different
Но
regulations of that.
уголовная ответственность,
However,
если
the
она не
the
связана
criminal
с
liability, if it is not
преступлением
linked with
умышленного штрафа
excessive
или уголовным
fines
наказанием,
or
то
criminal
считается ли
liability,
это такой
any
же
way it is seen as such,
самонасаждающей эффект на
that
свободу выражения?
has a kind
В
of
некоторых странах есть такое.
preventive effect for freedom of
Но вопрос
expression. In some countries, there is criminal liability, but if it is enforceable, that's the question. Many old democracies, even though they do have that provision, I believe they have that in France, but they do not really apply that often. Usually, monetary sanctions, financial sanctions are seen as adequate sanctions for defamation. Well, that is a case from Finland. I cannot find the spelling right now. It is Pentikainen. How the guy is spelled, that's a question. So I have covered all questions in the chat box. Maybe somebody would like to speak up. There is another question. What's the priority? What has the priority? Safety or freedom of assembly? This is from Daniil Polyakov. I believe you haven't addressed that yet. Yes, sorry, I missed you. Yeah, we have so many uh, questions. So what's the priority? COVID-related restrictions or freedom of assembly? There you need to look for the balance between the rights protected. COVID is a very dangerous infection. For some, it may be fatal. This is risk for life, risk for health, because consequences of COVID disease may be very different, and for some they may be very adverse. So the task of a lot of public authorities is to strike a good balance, to protect one right and to, as little as possible, interfere or limit the other right. And not always they find this balance. In Ukraine, I don't know where you come from, but in Ukraine, those measures that were taken by the government initially, when the lockdown was introduced, there a lot of those measures were criticized. It was even prohibited to walk in the park in fresh air without the mask. There was absolute prohibition to walk even in parks. A lot of lawyers, me included, we criticized this approach. We said that those were inadequate measures. On the other hand, now, yes, you're right. You see, you found that Pentikainen case. So sorry for interrupting myself, but I'm happy that you have found that case. So Daniil is from Russia. I see. Maybe you have even more stringent restrictions there. But the issue is that not a single right needs to interfere or impede another right. I mean, it's not only in Ukraine or in Russia that they introduce these restrictions. In Germany, in France, they do that. In many countries where they introduce prohibitions for protest meetings, they do that after they announce the state of emergency. I understand that they haven't done that in Russia yet. In Ukraine, it is not announced either. So so it is not about the state of emergency, and according to our legislation, only under that regime it is possible to limit rights and freedoms more to a great extent. And that is a fine line, fine balance, but you need to look for that so that where the state introduces limitations, they should not be excessive or restrictions. Well, I believe that the rest of the questions rather apply to freedom of peaceful assembly. So I believe that for at our next thematic session, you will be in the position to ask this question to another speaker. I believe that Ludmila has shared a lot with you already. She must be tired because we have not noticed that, but more than 2 hours have passed. So I believe that we need to release Ludmila now. And we are very grateful for this very rich session. I believe that participants have managed to learn a lot of useful things from it, and we will share the materials that you have sent. This is an announcement for the participants. We will publish these proceedings tomorrow, the day after tomorrow. You will be in the position to see them, maybe even earlier. I believe that here we can stop the recording. Thank you so much again. Thank you for your being so active, and thank you for this opportunity to work with you today. It was my pleasure. Same for us. So then I stop the recording. And as ever, couple of organizations